Arts and Science Fiber Group. We have an engaging lineup of sessions that promise to provide us with further insight. But before we proceed further, let us begin with this session with a silent prayer. Thank you for the, thank you for joining in the faith. To why
Rajlakshmi, your voice is breaking. So I welcome Dr. Ayapadas for the welcoming the participants and to introduce the resource person. Welcome, sir.
Uh, Thank you, Dr. Sister Sylvie and Matthew, madam. Sister, is it audible?
Yes, sir. Yes.
Thank you. So, good evening, all. On behalf of the entire organizing committee and organizers, I would like to welcome all the participants present over here. And yesterday, we have started this event, and during the opening note, the head of the institution had made a remark that we have participants from pan India, that means from different states, we have participants, and that too many academicians and researchers they have joined this platform. So great to hear that. And since there are participants from pan India, I would like to start a note about Trishul, because Vimala College is located in Thrissur. Because Thrissur is usually famous for temples and churches, and rather you can see fantastic churches with infrastructure more than Vatican. The churches are beautiful in Thrissur. So, but here, since we are in the midst of academicians, I just want to make a note that Thrissur is also famous for high quality higher education institutions. Because for your kind information, many colleges in Thrissur have secured highest grade in the MAC, that is A++. So last week I was in RGC, Trivandrum, to meet a scientist. He is a scientist G grade and very senior scientist. And because of Dr. R. Rajendran sir, we were able to meet that madam, that senior scientist. And then she told that she is a proud alumni of Vimala College Thrissur. So why I'm just mentioning all those notes here, so the participants should know the importance, and the Vimala College is one of the jewel of Thrissur or rather the Pan India. So with this opening note, I'm happy to introduce and welcome Advocate Arati Ashok. Madam Arati Ashok is a law graduate, and she has completed a law graduation in LLB in MG University and LLM from Cochin University of Science and Technology. And during both the degrees, she was a highly meritorious student, and she received various awards. She received various endowments. She was a gold medalist, and in PG, she was a second rank holder. So my point here is that she is not a mere graduate. Throughout her study, she has been the epitome of success. So she has been specialized in intellectual property laws and labor law. And continuing in her studies, she has published more than 20 articles and in national and international journals, which include Springer, Scopus, and various reputed publications. And she has been a resource person in various platforms, and she's been an invited speaker, and even she has presented papers in various platforms, including Singapore Management University. He has completed various online courses, and even from foreign universities like WIPO, World Intellectual Property Organization, University of Edinburgh, the Hong Kong University of Science and Technology, and the list goes on. And after her education, she has joined as an assistant professor in Hidayatullah National Law University in 2010, that is 2010. And then she has joined as a research officer in the IPR chair established by Government of India in Cochin University of Science and Technology. And currently she is working right from 2014. She is working as an assistant professor in the School of Legal Studies in CUSAT, Cochin. So, academicians and ladies and gentlemen, we have a rare trio here. The rare trio means we have an academician here, we have an hardcore researcher here, and we have a legal wizard here. So, I request all the participants to make use of this opportunity. And again, once again, a warm welcome to Advocate Aarati Ashok. Welcome, madam. Thank you.
Thank you, sir. Thank you for a very warm welcome. At the outset, let me express my gratitude to Vimra College as well as the RVS College of Arts and Science, Coimbatore, for giving me this opportunity. If I suppose we can start off with the session right away.
Yes, ma'am.
Okay. So I'll be just sharing a slide. Like ma'am was telling, you had a session yesterday, and because it's a group of teachers, I expect it to be extremely interactive. IP basically and copyright in specific is something that we have been dealing with personally for quite a long time. You might not be so quite sure that we have been using it very frequently. Are my slides visible?
Yes, ma'am. It's visible, but it is not in the
Yes,
slideshow, ma'am.
yeah. Full screen mode you
Full
can put it,
screen
ma'am.
mode.
Oh, just give me a minute.
Yeah.
Yeah, please.
Okay, it's still not a slide share for you people. Just a moment, please. Am I still visible or did I just go out?
Not visible, ma'am.
Okay.
Please present again, ma'am.
Hello, madam.
Yes. Please let me know if it's on SlideShare.
Now it's visible, ma'am. Please put the slideshow, ma'am. Please click on that, ma'am.
Actually, for me, it's slideshow. That is why.
Yeah.
Slideshow is on the home button. Just after that animation, you can see home, insert,
Yeah,
design.
yeah.
My
The
screen,
yeah,
it is showing a
click on the
slideshow. That is
slideshow button. Slideshow, yeah, you're around that. After between animation and record, you can see there.
just a minute. Because
Yeah, click on that from big. You can click on from beginning. Yeah. Now you have to go to you stop presenting and go to select the
my
window.
screen, yeah, but in my screen, it's slideshow. That's why.
Yeah, what you have to do is you have to switch over the window. Now you're showing the presentation window, you have to show the slideshow window. So just stop presenting and present again and choose the slideshow.
Actually, for me, it is a slideshow. That is the problem.
Yeah,
My screen is slideshow, but
ma'am,
I
but you are
don't think you.
presenting the presentation window.
Yeah,
The
I followed. I followed. Uh, Again, for me, just
okay.
a minute.
Or can you do one thing? Can you just present your entire screen?
Yeah, I'll do that. Is it the full slide that you are able to see now?
Yes, ma'am. Now it's okay.
Okay.
Yeah. you can.
Sorry for the technical glitch. So, talking about copyright, yesterday there was a session where you had an introduction on uh, IP in general and patents in particular. Now, when we talk of IP, we say it as products of creative minds, and you did see that there are various kinds of IP. Copyright being one. You had a discussion on patents yesterday. Trademarks and designs, and some of the other forms of IP you will be discussing in the further classes. So today, the attempt here is to impress upon you copyright, some of its aspects, and particularly from a point of view as an academic, as a teacher, and also as a researcher. Copyright is something that we use on a very daily basis. So, what are the things that we can do? What is copyright in general, and how particularly copyright is of importance to us as academic is what is being discussed. Now, yesterday when you had a discussion on intellectual property, Kavita madam would have mentioned that every kind of intellectual property confers a kind of a monopoly. Similarly, copyright also gives a type of monopoly to its creator. Now, we understand that when we say monopoly, it gives a specific right to one particular person who alone can come into the market. Now, to explain this, let's take a very common example of any movie. So, when a movie is made, the producer determines how and where the movie is released. So sometimes the movie would be released globally. You have a worldwide release. Sometimes you have a pan India release. It will be released throughout India and India alone. Sometimes the budget of the movie or the movie would have a very small market. For example, it could be a very, let's say, Malayalam movie with a very small budget, and the producer can determine to release it only in Kerala. So it's essentially the person who holds a right who determines as to how the monopoly can be exercised. Movie is one example. Some of us might be authors of books. The same logic applies that we would have determined how our books are released. Practically, Dondas might be a publisher, but then on theory, all of us who hold a copyright has a monopoly, and practically all of us have copyright. Now the question is, for what do we get copyright? Now the term intellectual property shows that you have to have some kind of intellectual input. But what type of intellectual input? Is it for an idea? Sometimes, not always, there comes what is called as blockbuster ideas. It might not happen to everyone, but then is that idea that is protected? Now, when I am taking a lecture on copyright, everything that I am saying here is most of it, or almost 99.9% of it, or for that matter, even 7% would have been already written down and explained by somebody else. It's already there in existence. Do I get a copyright for the lecture that I'm taking now, or for the PPT slides that I have made? What is that for which I get a copyright? The things that I'm saying, the idea of it, it's nothing new. There are a lot of people, all of us know something about copyright. There are people who know quite a lot about quite a lot of subjects, but then it is not the idea, but the expressions that are protected. Now, let's take an example of all of us would have written an let's say in a school would have written an essay on, let's say, a picnic or a park. And if you ask 10 students, or we are 100 of us, if we ask ourselves to write a small essay on a day out, a day of our picnic, and let's say I'm putting the premises as let us all go for the picnic to a beach, and then you write an essay on going to the picnic to a beach and we are watching a sunset. Even if I give this many details and ask you to write a small essay, let's say a page, of how the picnic was, all of us would essentially write different things. Still, the basic idea remains: a picnic, we going to a beach to watch a sunset. So much remains the same. Yet, if let's say 70 of us start writing an essay of one page, no essay will be ditto copy of another. All of us would express ourselves in different manner. The way we as teachers take classes for the same paper, for the same subject, for the same lecture, when we go and take a different class, you will not be repeating ditto ditto. You will be using different expressions. You will be using different examples in the class. So essentially the idea remains, but the way in which the idea is communicated differs. And copyright protects the way in which these ideas are communicated. So copyright legally protects what is called as original expression. And from a copyright point of view, original do not mean the literal meaning as new. Original means it originates from the author. So the lecture that I am giving now is actually original expressions. I would have never taken a lecture ditto ditto of the same things that I am saying, and it comes from me. So it's an original expression. It's for these original expressions and original expressions alone that we will get a copyright. Now, it's not that you will get copyright whatever you create, because it is a monopoly and it's a state regulated monopoly, which means that some law, in our case in India, it's a Copyright Act of 1957. Forget about the legislation's name, but the point is the law says for what you will get copyright, just like the law said for what you will get a patent. Beyond that, you will not get copyright. Now, the first is literary works. This is something that all of us are very, very familiar with. This is something that we create, something we knowingly, unknowingly create quite a lot. Literary work, from the copyright point and in the copyright sense, simply means that it has to be written down. It does not mean that it has to be in any particular form or format. Simply a written down format is good enough. And it is not even necessary that it has to be written down. For example, the lecture that I am delivering now, it's not written down. It's offhand. I'm speaking offhand, but still, whatever I am saying, I am expressing them in my original expressions. They are coming from me. Hence, this is also treated as a literary work for copyright. Now, the problem is of proving. I was under the impression that there would be a recording. Now, if there is a recording, what happens is the lecture I am giving, though it is not written down, it gets recorded. So it's still in a format where Dr. Jagadish, please mute. So what is required is that there should be an original expression, and to constitute literary work, it's not always necessary that it has to be even written down. Take another example where you have elections coming up and then the political party, the leader is giving a speech. The speech he is giving might also not be written.
Excuse me, ma'am. I think you are on mute.
Oh, I'm sorry. Now am I audible?
Yeah, yes.
Okay. So, from the point of view of a teacher, the lectures that we take in the classes, they are actually literary works. The lecture might not be written down. We might have a lecture note where you will be noting down the points, but A to Z of the lecture might not be written down. In spite of that, the full lecture is a literary work. The lecture notes are also literary works. The exam paper that our students write, the answer scripts, they are also literary works. If any of us have a habit of keeping personal diaries, they are also literary works. So literary work is quite large and quite wide in its scope. The second is dramatic work. The best example or the best way to say a dramatic work is a screenplay. Most of you might, when I say screenplay, understand that it's different from story. So, story is the classic example for a literary work. It tells you the gist of it in a particular way. But when you are talking of a screenplay, it's as if you can picture the whole thing. It can be enacted, it can be dramatized. So such works are called dramatic works. Choreography is also a dramatic work. You can perform it. Mime is a dramatic work. So these are again kinds of works that are actually created and performed usually within an academic atmosphere. You have a cultural fest, you might have choreography, dance coming up, you have mime competitions. So all of them are dramatic works. Of course, there is musical work. Musical work is nothing but the music. Keep in mind, when we are talking about a song, it has a lyrics and a music. The lyrics is a literary work and the music alone is a musical work. So if we're talking from a professional point of view, Javed Akhtar, he's a lyricist, would be creating a literary work, and A.R. Rahman, who is the composer, creates the musical work. So musical work is only the music, no lyrics attached with it. And then we have artistic work. Artistic work, the best example I can say is photography. All of us have phones, all of us have cameras in it, all of us are photographers. All of us take quite a lot of photographs. Some of us post quite a lot of it on platforms like Facebook and Instagram. And when we accepted the terms, we would have never read, but there is a clause which says that we permit them, we giving them a license to use the photographs that we upload for a worldwide purpose, for whatever purposes they want. So actually, we are entering into a legal contract where copyright is one of the elements when we are entering into these social platforms and obviously uploading our photographs, ours or any other photo. The other is sound recording. Sound recording is basically recording of any sound. So if this is being recorded without the video, just the recording, it becomes a sound recording. What happens is when we are in lectures, if it is a huge class, if it's a very long class, students might be recording the lecture. It could be in a phone, that is a sound recording. In today, what we do is in WhatsApp, we send recorded messages. So a lecture can be recorded and shared. When sharing on WhatsApp, when you're using the record button and when it's recorded, it becomes a sound recording. And then obviously we have cinematograph films. The classic example is cinema, but it's not just cinema. Documentary, advertisements, cartoon films, all of them fall under the category of cinematograph film. So copyright protects these 6 categories of works, and only if we can attribute the work we created to one of these categories can we claim copyright. And again, as a teacher, we might be creating all these works, and as a teacher and as a researcher, you might be using all these works also, depending on your discipline. Now we will come into how we can legally use these. Now, when we are talking about creators, the person who creates a work, a copyrighted work, he is usually called the author of the work. So, in the literary context, or as far as literary works are concerned, or dramatic works are concerned, he is called the author. In relation to musical work, like the example I was talking about, A.R. Rahman, he's called the composer. When the work is a painting, like M.F. Hussain, he's called an artist. And if it's a photograph, it's called a photographer. Now, I'm just naming the famous personalities. What needs to be understood is that having copyright and having a market for the work has no relation at all. MF Hussain has a painting, and let's say I make a painting. From a market point of view, there might be huge value difference between the work created by MF Hussain and the work created by Arati. But for copyright, they are one and the same. Whatever rights MF Hussain gets, the same rights I also get. So copyright does not have anything to do with the market success or the market failure of the work, but simply with the fact that the author has created original expressions. Now, these four categories, literary, dramatic, musical, and artistic work, they actually have a very long lifetime. For example, yesterday there was a discussion on, I'm sure, on the term of patent, and patent is only for 20 years. But copyright exists for life plus 60 years. Now, look at the copyright that we hold. All of us would have written articles. Some of us would have written books. All of them are literary works. And the copyright for that work subsists 60 years after our death. So for me, my articles, my copyright will live 60 years after I die, which means copyright survives me and it goes to my legal heirs. So if I decide that all my property shall vest with my son, my copyright would also go to my son. If I decide that all my property shall go to some other person, I write a will and decide, then copyright could also go with that person. So in that extent, copyright act just like any other property. But when we come to cinematograph, film and sound recording, CF and SRR, cinematograph, film and sound recording, we have a different scenario. Now, cinematograph, film and sound recording, the law recognizes the producer as the author of the work. Are we on the same screen? Can you just tell me which is the screen that you are seeing? Hello?
Yes, ma'am.
Can you just tell me which is the screen? Okay. You are still on dramatic works? Okay, because my
Yes,
slides are
dear.
moving.
This is only, sorry, ma'am, this only drama that is the screen is
Yeah,
showing.
I just saw it. I can see, but the problem is, okay, you are on a different screen now. Has the screen changed now?
Yeah, ma'am, sure.
So this is what I was trying to explain. So when we are talking about literary, dramatic, musical, and artistic works, we have author. In literary and dramatic work, we call him author itself. In musical work, we call him the composer. And for artistic work, we call him the artist. If it's a photograph, we call him the photographer. And the term is, or the duration of the right is life is 60 years. But in case of cinema and sound recording, because the law understands that they are works which require huge investment, it's the producer who is understood as the author of cinematograph, film, and sound recording. You would have noticed in any award function for the best movie, it's the producer who comes and takes the award. It's never the director. You will have a different category called best director. But for the best movie, it's the producer who comes and takes the award. This is precisely because under the Indian law, the understanding is that producer is the owner of the cinema. And for cinema, the lifetime of the copyright is only for 60 years from the year next after the cinema is released. For example, for all cinema that has been released in 2023, copyright will be calculated from next year onwards, from 2024 up to 60 years. So that is the term of a copyrighted cinema or a sound recording, as the case may be. Now, what are the rights that we have as a creator? We as academics, as teachers, we are actually quite a lot of creators. This is the common norm that is used in academia, that you have to publish or you perish. So if we have to remain in academic, we have to keep on publishing. And as creators, there are two categories. We as faculty members, we do create. Some of us might be students also, might be holding dual capacity. For example, I am a student, I am a research scholar. So I am a faculty at one place and also a research scholar. And in both these capacities, I create quite a lot of copyrighted works. We also do this. Now, as faculty members, as teachers, we create some of the copyrighted work as part of our employment and some of the part as purely scholarly work. As a student, all what you create is only scholarly work. It's only when you are in employment, you also create some copyrighted work, which is part of your employment. Now, as part of employment, we do quite a lot of administrative work as well as quite a lot of academic work. Administrative work, yes, obviously, if you create copyright, again, it falls into the same category. But more importantly, we create a lot of academic work. One being, most of us do set quite a lot of question papers. Now, do question papers have copyright is the first question. You think question papers have copyright? Yes. The answer seems no. Yes, question papers have copyright. They are literary works. It's not easy to set question papers. You require quite an intellectual input to think of how to put a question and then draft the question paper. Not the individual questions per se, but making individual questions also is not an easy business. If your question paper is 1 + 1 is equal to blank, of course, there's no copyright. But then most of us are teachers at the college level. And the questions you said might not be so simple as asking 1 + 1 is equal to blank. So the question paper as such is understood to be something that requires some amount of intellectual effort and creativity. And question papers do have copyright. And as teachers, question papers is something that we make quite a lot. Think about the number of internal exams that we might be conducting. It might be setting questions for university exam papers. So that is one set. The next is we might be preparing quite a lot of lecture notes. The university or the college might demand that there should be lecture notes prepared. During our online classes, during the COVID sessions, we would have had produced quite a lot of video recordings to be sent to our students, quite a lot of audio recordings of the classes, which would have been sent across. There might be MOOC classes that we are engaging. There might be other online platforms where we are taking classes. So all this is part of your academic work as part of your employment. If not in this job, we would not have done all this. We would not have made lecture notes if not for this particular job. So in cases where as part of employment, we are generating copyrighted works, all the works that we create individually, I am the author, but the ownership, the rights of the work belongs to my employer. So in my case, all the lectures that I take in my college, all the lecture notes that I create, all the question papers that I generate, everything belongs to Cochin University. So I am the author of the work undoubtedly, but Cochin University becomes the owner of the work. So there's a difference in copyright as to who is the author, the person who creates, and the owner who has control or rights over the work. So everything that is created as part of employment belongs to the employer. As the case may be, for me, it's my university. And this is, I'm just talking about the copyrighted works. So if as part of employment, again, you generate, it's not just literary work. I've just put examples of literary work. Let's say there is a drama that is being played in the college, or you are recording it for the purpose of teaching your students. A classroom drama is being prepared and recorded. That becomes a cinematograph film, and if it's part of your employment, it also belongs to the employer. So every work that is generated in the course of the employment belongs to the employer. But then there's this whole other scholarly creations, which the employer does not mandate you to. You want, you can do. If you don't want, also, it's fine. The research articles that we do as a scholar, as a research scholar, the research work that I do, the PPT presentations that I have made for this, the PPT and the lecture is actually literary work, but then this is not part of my employment. So all these works, as long as they are not part of the employment, I am the author as well as the owner of the work. Now, when can I use scholarly articles? Is the question. I'll come to this picture framework in a minute. There's one more slide. I'll come back to this, or it's repeated again. Now, so we have to keep in mind as to what are the works that we are generating during our employment, as part of our employment and not as part of our employment. Now, even for our personal research, we might be using the facilities provided by the employer. You might be sitting in your office and you might be reading. Let's be very honest. There would be databases which are subscribed by the university. Individually, you might not be able to subscribe them. So you get access to the material from the university, but you are using it for your research. If it is your research as a scholarly research, which is not as part of your employment, the copyright belongs to you. You have to keep that in mind, because when you send articles out for publication, you will have to enter into a contract agreement with them saying that you are the owner of the work and you would be licensing it to the publisher to publish it. Now, yesterday with patent, it was discussed that patents has to be registered. Now, copyright operates on a totally different platform. Copyright need not be registered. The moment you create the work, copyright is vested on the work. Like I said, the question papers you have created, all of it have copyright. The answer papers you have written all the way along, right from class 1, if you started writing exams, till whatever you have studied, all the exam papers you have written, they all have copyright. Copyright registration is not mandatory. There are a lot of instances where copyright registration helps you, undoubtedly, particularly if there is a litigation. So from a practical point of view, particularly when it is a movie, when your financial interest is very high and is at stake, normally film producers and producers of sound recording usually register copyright, but it's not mandatory to register copyright at all. And even without registration, all of us hold valid copyrights. Now, what does having copyright mean? What is the benefit of having a copyright? In the initial part, I did mention that it is a monopoly, which means that in market, it has some effect. Having copyright does not mean that your work will be successful in the market. Of course, it doesn't mean that. But then only you holding copyright gives you the market advantage or the market exclusivity. When you create a work, again, let's say the example of a movie. When you create a movie, you determine as to how the movie has to be exploited in the market. Should you release it in the theater, or should you release it in an OTT platform, which will be more economically viable for you? So as a producer, you get to decide this. So if you think that first a theater release would fetch you more money, then obviously you will release in the theater. But if you determine that no, the bigger revenue would be to give it to a OTT platform, then you will give it to an OTT platform. Or you might decide to put it the satellite right and give it to a TV channel, not even going to the OTT platform. So in essence, if you have copyright, you can determine as to how money can be generated from the work. Now this again, when we are talking about scholarly writings, again, we can determine as to how, when we write a book, whether we want, which publisher we want. That's the first question that we have. Now, again, let me emphasize that having a work does not mean that you have a market guarantee. So, when you approach a publisher, the publisher might look at your value and your worth. For example, if Amartya Sen writes a book, and then Amartya Sen can decide which publisher to go to, because Amartya Sen has an established market and a huge reputation, which might not be my case. So I might be at a lower bargaining end when compared to Amartya Sen if we go to the same publisher. But then with the publisher, we can determine how many copies to be sent out in publication. So the publisher would assess the market. Let's say I'm writing a book on copyright. So I'm going to a publisher, let's say Oxford University Press, and they are assessing that there are, let's say, 5 other books on copyright, and this many is the probable number of people who will be buying the books on copyright. And then they have a market assessment, and based on that they would say, of course, let's, for the first edition, let's put out 1,000 books and see how it works. So this is my right, whether I want to give the right to Oxford or not. If I do not give them the right, they cannot publish my book. So that is the right of distribution. I can decide not to give to any publisher at all. I want everyone to read my book. So I am determining and deciding that let me put it on open source. So I'm creating a web page on my own and I'm uploading my book, making it freely available for all. Or I can have the book uploaded in my university website, in the library, online library platform, where it would be accessible to all my students. Or there are quite a lot of open online depositories like SSRN, where I can put it there and can let people read it for free. Still, I have a copyright. I'm just not looking for economic benefit out of it, simply because for an academic, your scholarly article might not be a source of your revenue. What you might be looking from an article might be a pure recognition. But for someone who is making a livelihood out of it, think of an author who's like uh, J.K. Rowling. She makes her livelihood out of sale of the books. So for such persons, having an economic right matters. Now let's take an example related to our area. For example, question banks. We did discuss whether question papers have a copyright or not. Question papers do have copyright, and because of that, question banks are made. So you have quite a lot of question banks. University publishes, so previous year's question papers would be available. Sometimes most universities give it out for free, but otherwise you have a question bank which would be printed by the university, which can be bought, or by the CBSE board or by the ICSE board. The previous year's question papers could be made available for money. It could be sold as books. So that is where the market lies. But apart from that, generating money, we have the other side of what is called as moral rights, where you are recognized as the creator of your work. So, like the moment you say Das Kapital, even though we have not read the work, we immediately know Karl Marx. So the work does not have any kind of market, as far as any kind of copyright today, because life plus 60 years has expired so long, which means there is no more copyright in Das Kapital. But still, it's always associated with the name of Karl Marx or Rabindranath Tagore and Gitanjali. Though there is no more copyright has expired. When you talk of the work, you immediately recognize the author. So it's a kind of appreciation and creating a linkage between the work and the creator. And all of us as academics, this is something that we look for, what is called recognition, peer recognition. I have written this, and I have written this is recognized for us in other formats also. For example, when you put out your portfolio, or when you put out your the UGC mandate of how to get a promotion, you have to show that your work has been cited. where you use mechanism like Google Scholar or iIndex or H-Index to say that I have been recognized by my peers. So at many fields today, recognition becomes necessary. And this recognition is guaranteed under the law through moral rights. So when I have written an article, nobody else can claim that that article belongs to them. So that is protected under the moral right. So in spite of all this, so like I said, all of us do have copyright. Let's say our copyright has a market also. In spite of that, would there be anyone in this classroom who has not downloaded an article or a book or a music? All of us do download books and articles, right? Because essentially, just to quote Newton, that all of us are standing on the shoulders of giants, and that is how we see further. So, if we have to learn something, we need to know what is happening around the other people. What are they doing? Where is the state of art in this particular stream of knowledge? So, to read that, we require access. So, sometimes we depend solely on the library, but today we depend a lot on the access being provided online. So once we get a new material, we find it interesting, we download it. And downloading is reproducing the material is somewhere and you are making a copy it into your system. So you are downloading. So let's say that it's an article written by one of you participants and I am downloading it into my system. So even when you have a right to reproduce the work, I as the user have certain rights. First is that because I am a researcher, I am a learner. And to facilitate my learning process, there are quite a lot of things that I am permitted to do. These are things that we do every day. We are just not realized that all this is captured under the law also. So downloading is something that we very freely do. All of us have downloaded sometimes books, sometimes articles. And when we say articles, we have downloaded the complete article. 10% of the work has been downloaded. Books, we might be downloading sometimes in parts. Sometimes you get chapter wise. You will require only one chapter. So you are downloading only a chapter. Sometimes you might be downloading the whole book. Sometimes we might be downloading movies. I'm not sure if any of you have tried. When we talk to students, obviously they do download quite a lot of movies also. And you have different platforms to do it. At a point of time, it used to be torrent. Today, it's Telegram. So it just keeps on changing. You can share books. There are quite a lot of groups in Telegram where notes are shared, books are shared. I'm talking from a law book point of view. I'm sure you would have in your disciplines also quite a lot of groups where new books even would be shared. The question is, can you do this legally? We can do this legally, provided these are the reasons or these are the grounds when you can do it. When it's for your private or a personal use, including research. So if private and personal are different, because I'll come into it. Because when I'm downloading an article, let's say I'm downloading an article on copyright. I'm using it for my study and I might be circulating the article to all of you. So it's not just I am using it, I am also supplying it to quite a lot of people. There are 70 in the class. I'm giving the article to 70 of you. It's not my article. But the article, I think, is essential for all of us to understand what is copyright. So I'm making a copy and I am giving each of you a copy. Internet permits that. So, or the digital technology permits that. I can attach and send it to you is one way. On WhatsApp, I can send as a copy, which you can further download in your system and keep. So multiple copies of the same work would be made. All this is permitted. You can read, you can create notes, you can copy and paste. When you copy paste, you have to respect moral rights. That is why in research terms, what we say is we put citations, we give references, we acknowledge from whom we are taking. So it's not just plagiarism or being ethical while doing research, but also a mandate of copyright law. that you respect the moral rights of the person from whom you are borrowing. So this is called fair dealing. Now the question is, this is the graph or the picture that was earlier also. So the question is, when would something be seen as fair dealing? Because only if your dealing is fair, you are within the premises of the law. If not, you have uh, consequences. Now, first is the purpose of the use. Why are you using the work? So, if I am downloading a work for the purpose of my education or for the purpose of educating my students, both of them are justified. So, the first thing that the law will look is, why are you using somebody else's copyrighted work? Because you are using it without their permission. You are not asking them a permission. You are not paying them any money. If you ask them permission and pay them money, then it's fine. The law has no problem, because the owner would have gained an economic return. But what happens when we do research is, we simply download the material and read and circulate. So the first question asked is, what is the purpose? The second is, what is the nature of the material? Is the material educational in nature? Is the material an academic writing? Or is the material let's say, a novel? Now, if I can again just ask a question, all of us, when during our period of study, would have necessarily taken photocopies when we were students. But has any one of you photocopied a novel for reading? Is there anyone who has photocopied a novel for reading? Usually we don't. I have never come across someone. Today you might download novels and read, but actually taking a photocopy of a novel is not something that I have seen. The simple reason is, it's only when it's academic material and something that you urgently require for a particular purpose, not for your leisure, that you actually use fair dealing. For movies, the only exemption you'll find, most of us do download movies. If you download movie, you don't circulate it wide across, because you have a problem with copyright law. The next is, what is the amount that is copied? Have you copied the full work, or have you copied only parts of the work? Now, what happens is, when you download an article, let's say it's a 15-page article, you will obviously download all the 15 pages. Sometimes it's a book. You might not need the full book, but then the downloadable version is available for the full book. But let's assume a situation where chapter wise is available for download, and you want only a particular chapter, and then you are taking that particular chapter. So it depends on what you require and how you can download or how you can get access. But the most important one is the market impact. With your activity, are you causing any substantial, significant market impact for the other person? If you are making one copy of a book, of course, undoubtedly, otherwise you might have had to buy the book. But most situations, when you can afford the book, you will not download the book. But in situations where either you don't have access to the book itself, for example, the book is not there in the market, it's an old book, but it's available in your library, we might take photocopy. Otherwise, the book is very costly. It's not possible individually to buy the book. So either you borrow from the library or you make a photocopy of it. Similarly, most of the material that we are looking online today, it might not be available to us. So we are just making a single download, or might be sending it around to a small number of people, where there might not be a significant market impact. And it's a combined reading of all this together that determines whether your activity is fair or not. So if I download a movie and then I'm staying in my hostel and I'm then circulating it to all my hostel mates, and then none of us go to the theater to watch the movie, of course, my activity cannot be called a fair dealing, because one, the purpose that I'm using is simply leisure and just not mine. I have been circulating it to the extent that it has caused some kind of a market impact. So in such situations, the law doesn't treat it as fair. Now, when it comes to computer programs, again, I'm not sure if there are teachers from programming side, but in case I just put it up. So in case of computer programs, there are certain other things that we need to be very careful about. For example, most of us have access to certain softwares, right? Most of us might be using open access. Our phones could be Android operated. But let's say for those, or at least in the system when we are using MS Office, do actually we buy a software? Or take the case of an antivirus. You pay, but are you buying the software? I'm not talking of a situation where you don't make any payment, okay? You did make a payment. You made a payment and you installed a software. But please keep in mind, we are never buying a software. It's always a license. And usually the license is yearly renewable. So that is why every year the antivirus software needs to be either bought or updated. We are never buying them. It's only a license that they give us to use it for 1 year. Now think that I am a computer programmer or a teacher who's teaching programming, and I have created a program. Let's say I have created a game, and now the game needs to work not only in open access. I believe all of you understand when I say open access what it means. Open access is where there is copyright, but then the source code is available openly and nobody is claiming any rights over it. It's available for free, though there is copyright. So most of our phones, Android is open access in that sense. But if we are talking about Apple or BlackBerry or Microsoft, they are proprietary softwares. So I have developed a game and I want my game to work in Windows. So if my game has to work in Windows, there should be some part of my program which makes it operate on the Windows, let's say platform or the OS. Now, for that, to obtain those information, if my program has been independently created, I can legally make copies of Windows OS. Similarly, if I want to study a program, like I said, I'm a computer guy, I'm a computer programmer or a student. I want to study how programming is done, the underlying functions, principles. For that, again, I can make copies of the program. Otherwise, touching computer programs is not something that the law takes very lightly. So with relation to computer programs, we have very strict norms. But for teaching, the law has provided specific set of exemptions. One is in the course of instruction. So for purpose of teaching in my class, I can reproduce works. I can make copies of the work. I can distribute copies of the work to the students. Like I said, I can take photocopy not only for my purpose, but if there are, let's say, 5 other students and I think they also need this photocopy of a particular work, I can take copy for them and give it to them. So it can be exercised by a teacher and pupil in the course of the instruction. But we have to come within this capacity of a teacher and a pupil. Only then this comes in. For setting question papers, if you want to reproduce a work, this is something which is done quite often in literature. A portion of a particular work might be quoted in the question paper and asked as to what do you think the author intended, or what is the current social relevance of this particular work. The work can be quoted either in part or as whole. And again, while giving as answer, so if you are writing an open book kind of exam and writing an answer and you want to quote from some work, you can quote, reproduce it very freely. So teaching, most of the activities that we as teachers and researchers do today are specifically given under the Copyright Act as exemptions. And this is something again that's very commonly happens in educational institutions. There will be quite a lot of dance, there'll be quite a lot of performance, all new songs would be played. There are instances uh, very common in my department also, where we see movies which have certain kinds of, for example, uh, some which have legal significance, movies where either procedural laws discussed, or access to health medicines are discussed yesterday, etc. We as the teacher and the students, we sit together and see movies or documentaries inside the campus, inside our department. The question is, can we do it? Yes, we can do it. We can perform dances, play songs, see movies, provided the audience is limited to the students, staff, and parents. So you can't have it out to the general public, but on a limited audience, others' copyrighted works can be freely used. Now, these are the people who are authorized to use. Okay, first the author will permit, like I am the author of a work, I will permit the publisher to print, so he becomes a permitted person. If it is my work and one of you are downloading for reading for your academic purposes, the law permits you, so you are also authorized by the law. So apart from these two, that is, if any unauthorized person exercises the right, it's called an infringement. So my right is being violated. And in such situations, I have remedies, the law coming into action. We would have seen quite a lot of situations where movies are being stopped and people are being arrested. And there was a time when in Kerala, people might remember Rishraj Singh used to be the head of the police. There used to be tremendous raids of these CD shops, taking away all the CDs because it was being sold without authorization. Copyright is a criminal law in that sense. So if you are on the wrong side of copyright law, you could be imprisoned. So these are the remedies. Of course, there are penalties and imprisonment is also there. So this is the gist of what copyright law does and copyright law works for all of us. So that's with the presentation. I can take up questions. Okay. Is there a question?
Yes, participants, it's a time for discussion. If you have any queries, you can ask directly, or you can post your questions in the chat box. Please. Yeah, questions in the chat box, ma'am. From Dr. S. Geeta Lakshmi. That was a clear presentation on copyrights, ma'am. That's a compliment.
Ma'am, good evening, ma'am.
Good evening.
It's Saravana Kumari from RVS CAS, ma'am. I have a question, ma'am.
Yes.
First of all, I like to say something about your presentation. It was very clear presentation, and even I can say that I have copied your way of presentation from you. Excellent presentation, ma'am. One more thing, I have a question, ma'am. Now, so many publications they published image. They are publishing the images, ma'am, in their article work. So, if we like to copy the same material, the images, now, how to get that permission and make use of it, ma'am?
Now, when you are taking images are protected by copyright. So one thing we can do is, if you are using the presentation, the picture for any presentation, which is an academic work, then one way is you can take the image, and at the end of the slide or the paper, you can give the citation as to from where the slide or the image was taken. That is one way. And
Okay.
again, some of you might have seen the symbol CC written,
Yeah,
not one
Creative
C, but
Commons. Yes.
Creative Commons. Yes, so sometimes what happens is, when images are put out, they are put out as Creative Commons. which means that you can freely use, you only have to attribute. So there's nothing illegal about usage, provided you recognize from where you are taking the image. So when you are taking the image from Google Images, it has a settings where you can actually select images which are only from Creative Commons or which have Creative Commons license. So they are giving it out as free to use, provided you attribute. So that's the safest way to take images.
Okay, ma'am. Thank you so much, ma'am.
Yeah, just to add on to, if you are very particular and want to use a copyrighted image and
Okay.
you think it is not within fair use, then you will have to contact the person and get their permission.
Okay, ma'am. So they have to give the permission
Yes,
in
if
return.
you yes, in return you have to get the permission. Otherwise, it should be a fair use. So if, again, I'm just repeating, if it is for your academic purpose, 99.9% of the time, it goes as fair use. But another way is, let's say I am an academic, but I'm writing a book. And the front cover of the book, I want to use the photo. But the front
Yes,
cover, I will be publishing it and I'm selling the book for money. There I cannot claim fair use. So if that
okay.
image I'm using belongs to somebody else, I have to take their permission, written permission. There should be a license of copyright.
Okay, ma'am. Thank you so much, ma'am.
Yes, ma'am. One question in the chat box.
Yes.
Since question from Mary Jyoti, ma'am. Since registration is not necessary for copyright, won't it be difficult to establish your claim?
Yes, proving copyright can be a very tricky business. Like I said, the lecture that I gave now, I have a copyright, but I don't have the whole lecture written down. So if one of you, let's say, delivers the exact same lecture, it's impossible, okay? But let's assume that you are able to do it, and I am saying my copyright is violated. It's very hard for me to prove that this is what I had said, because I can't say I took a class on copyright, you took a class on copyright, and my copyright is violated, because copyright cannot protect ideas. You have to reproduce exactly what I said, or at least substantially the same things that I have said. So if it is registered, it's easier to prove in a court. So that is why, in case of, I said, like when the financial stakes are very high, in case of cinema and sound recording, they usually go and register. Because if you have to go to court, having a registered copyright is easier than not having it registered. So it's only from the litigation point of view, it makes sense. And yes, if there is a chance that there might be a litigation, it's always advisable to register copyright. Yes.
Ma'am,
Yeah, there's a
there is a
question.
question. There's a
Yes,
question
yes.
in the chat box.
Uh,
Yes.
for electronic circuits, no, you cannot. Your electronic circuit, what happens is, if you are talking of a drawing of a circuit, you can say it's an artistic work. But again, the functionality of it can't be protected using copyright. Now, forgive my ignorance on what is actually an electronic circuit. If you are talking about a semiconductor chip, if that is what at the end of the day it becomes, you have a separate legislation. But otherwise, if you have a circuit which is innovative and comes to the standard of patent, you can protect it under patent, because you're talking about technology. Copyright is not on protection of technology and technological drawings. You're talking about more creative, what you call cultural works. So I hope I'm clear on that. So circuits, you won't get copyright.
Any more questions?
There are a couple of hands raised. Are they for questions?
Yeah, Dr. Sendil Kumar, please ask question, sir.
Yes, sister. Madam, very good evening. Thank you for your nice presentation.
Good evening, sir. Thank you.
I have a couple of questions, ma'am.
Yes, sir, please.
I have three questions for you. All very simple, probably all very useful for everybody in the platform. As a professors, we are not allowed to copy a single page from a Google. Can you hear my words, ma'am?
Yes, sir. Yes, sir. We are not
Yeah.
allowed to copy pages.
Yeah,
Yes.
as a teacher, we download all the literatures and everything from Google. And is it sufficient to acknowledge our courtesy at the end of the material we supply to the students? Number one. Number two, second question, open source, what's any lifetime for open source? For example, if I am publishing something for my concept in open source, my concept is copied by someone else. How to claim my copyright? Question number two. Question number three, for example, you take a CSIR questions, which is published by, this owned by Government of India. But there are a lot of textbooks, they copied the question paper and claiming copyrights are reserved. How these publishers claiming these HR questions? These are
Okay.
my generic questions, ma'am.
Okay. The first one regarding downloading material. When we are downloading material and giving to students, we are not saying the material is ours. We are saying that I downloaded this material. The material belongs to somebody else. It's evident that we are downloading material belongs to somebody else and giving to the students. So we are not violating any moral right there. We are just giving them to the students. The question is, if it is for their education purpose and we have downloaded it, it is fine. We are within the law. Coming to the second question of open source. Now, when I say open source, it means that I have a copyright. Creative Commons is an open source. It means that you have copyright. Copyright is same, lifetime plus 60 years. But I do not want to exercise the right because I want you to freely read and use my work. So I'm not, for the science teachers, I'm not sure you have a depository. For social science teachers might be using SSRN, Social Science Research Network. Most of us might be uploading our papers there. So when we upload our paper there, the understanding is that others can freely download and read it and use it also. So if they want to make quotations from it, if they want to circulate it, they can do all of that because SSRN works on Creative Commons. So have open source means you have copyright, but you are still freely letting others to distribute the work and use the work provided you are acknowledged. So my work, whoever uses have to use and say that it is my work, but they can freely use it. But if at any time, let's say, sir, your work is available for me, I am using it and I am using it in a way and saying, I'm quoting you in an article and saying something that you have never said, saying something opposite of what you have said, and you have a problem with the way I have treated your work. Even though it is open source, you can give a case against me because I violated your moral right. So even if it is open source is only a license to use it with acknowledging you and all the moral rights, saying that it is your work and treating your work with respect. So if I don't do it, you have remedy, even if it is open source. Now what happens is, if you don't want it to be in open source anymore, then you have to revoke the Creative Commons license or revoke it from a platform, or simply with the article put a C in a box, in a circle, which shows that you are claiming copyright. And when you are claiming copyright and I am using it, then again the fair use provision is there, that is legally given to me. So I can still make free use of it provided it is fair use. If it is not fair use, you can always challenge me. And coming to your third question on the publishers coming out with question banks. Now, what happens is the question papers belongs to Government of India, CSIR question papers. The government has put it on what is called as open, let's say open source or public domain, it's commonly called. Anyone you want to learn. You want to print and publish, you print and publish. So let's say I am a publisher and you are a publisher. So I am taking some question papers. Let's say from A to Z, all the question papers I might not be taking. I might be taking selective question papers. So there is a process involved in me selecting which question papers I have selected. Sometimes the question bank might be, it might not be question paper wise. It might be simply questions from this year's exam, from this year's exam, from this year's exam, which means I am putting some kind of intellectual input to identify which are the questions that have to come up in my book. So that is why the printers claim that over that book they have copyright, not on the question paper, the book that they have created. I'll give another example, which probably might be easy to understand. Let's say all of us are familiar with A.R. Rahman. I am trying to make let's say 10 songs of A.R. Rahman's best romantic songs. I am trying to select 10 songs. And all of you are also trying to select 10 best romantic songs, which means that we will have to put some kind of input, listen to all the songs, and then choose which would come within the 10. And my 10 might not be the 10 that you choose. So there, the choices that we make are different. It's called a compilation. So my compilation and your compilation would be different. And I will have invested intellectual efforts in creating this compilation, just like you would have put in the effort to make the compilation. So for that compilation, I am saying is my intellectual property. I have identified these 10 as the most significant. And for that, I need to get a copyright. So it's not basically on A.R. Rahman's songs, but on the fact that I have identified these as the best 10. Same is the case with the question paper books or the question banks. This happens because the government don't want to exercise their rights and say, whoever wants, print and publish, no problem. So as a printer, I'll be choosing and saying that these are the things that I chose. Don't copy the structure and organization of this work. The questions are not mine. Am I clear with that?
Yeah, sure. Sure, ma'am. Sure. Thank you. Thank you very much for your answer.
Pandey sir, is that a question?
Any more questions from the participants? Ma'am, I think the session was very clear for all. Yes,
Thank you.
yeah. No questions are there. So once again, thank you, ma'am. So now I would like to invite Dr. K. Rekha K., Associate Professor, Department of Botany, Vimala College, to propose the vote of thanks. Welcome, Rekha, ma'am.
Okay, sister, thank you. Am I audible, sister?
Yes, ma'am. Yes.
Okay. So, respected resource person, Miss Arathi Ashok, and my dear participants. Today, on the second day of FDP, we had the privilege of delving into the intriguing world of copyright laws, thanks to the expertise and knowledge shared by Miss Arathi Ashok, Assistant Professor, School of Legal Studies, CUSAT, Cochin. With the clarity and enthusiasm, she guided us through the intricate web of copyright regulations, enriching our understanding of the fundamental principles that govern creative ownership. Through her insightful presentation, coupled with real-world examples, we not only learned about the legal underpinnings of copyright laws, but also gained a deeper awareness of the contemporary challenges posed by the digital era. The session has undoubtedly enriched our academic journey and equipped us with the vital insights into the realm of intellectual property protection. On behalf of the organizing committee of this FDP program and all the participants, I extend our heartfelt thanks to Ms. Arathi ma'am for this enlightening session on copyright laws. Thank you, ma'am. I also want to acknowledge the enthusiastic participation of all the attendees of the program. Your active engagement, thought-provoking questions, and eagerness to learn have added immense value to this session. I would also like to express our gratitude to the organizers of this FDP for arranging such an informative and enlightening session for us. This program has proven to be an excellent platform for professional growth and exchange of ideas, and we are truly grateful to DBT New Delhi for funding this program under DBT Star College scheme. Once again, thank you all for being a part of this program. May we continue to enrich our classrooms with such endeavors and creative pursuits while upholding the principles of copyright ethics. And I also wish more and more such enlightening sessions in the coming days of this FDP program. Thank you. Thank you all.
Thank you all. Thank you, sister.
Thank you, Rekha ma'am.
Have a good day.
Yeah. So let's wind up today's program. Thank you all. Thank you once again.
Thank you, Gina. Thank you.